NACDL is the association of the nation's criminal defense bar.
Good morning, and may it please the court. In front of you, you have two evaluations of mental health issues relating to my client. In those two mental health evaluations that you have different opinions, one from the state and one from the defense. By the time we're done today, Your Honor, in this hearing, I would like you to consider our report as being more valid for the issues presented to you to provide a departure from the federal sentencing guidelines to a sentence that is more reasonable. Well, Ms. Shein, I've read the reports. What else is there to say? Well, Your Honor, I think once the two witnesses testify, you will see that our witness and expert has a better perception of what this client has done and what this client's mental health condition is about and how it affected the criminal behavior. Well, Ms. Shein, let's proceed. Now, that's a story I'm going to finish at the end of this speech. And the reason I'm going to finish it at the end of the speech is because I want to tell you all how we got to the place where my report ended up being the one that the judge relied on in sentencing our client. And I'll tell you what our client did and how he got sentenced at the end of this opportunity to chat with you about cross-examination of the mental health expert. And you've been hearing a theme throughout the entire experience here so far about knowing your expert and knowing the expert's background and circumstances and who they are and what they do, how they do it. And in psychology and in psychiatry, it's a massive amount of information you have to absorb to determine what type of cross-examination questions you want to present to your witness. And look, if you get one golden nugget from my conversation with you today, then I've accomplished my goals. But in the materials I provided you lots and lots and lots of questions that may work for you in a certain situation. Now, all the questions you don't want to use, obviously, because some can hurt you if you don't know the answer. But those questions that I've given you give you a platform and a foundation in which you can go forward with the particular expert you have to cross-examine. In part of that, on page 12, I was drinking tequila. And as a result of that, the numbers are different than they should be. So don't get confused. It wasn't because I was over-medicated. I was actually not medicated enough. Nonetheless, so you'll see the numbers are a little bit different, but the questions are there. So the first thing I want to talk about is to know your experts. These are extremely important issues. If you don't know the expert and don't understand what the expert is there to do, when it's a federal or a state expert being submitted to give your case less benefit than if you presented your own expert, then you're going to get into trouble. So the first thing you want to do is study any articles they wrote or books. And I will tell you a little quick story. And I don't know if any of you know Barry Cohen. He's an attorney out of Tampa, Florida. He died recently, and unfortunately. But I had the privilege of working with him on a case, and he was cross-examining a psychological expert that was involved in his case. And what he did was amazing. I watched him lead this psychiatric expert into questioning about a particular element of his findings in the report that he gave the court. And he led him right through it. And then he said, well, I have a book. I know you wrote this book. Can I show it to you? And he did. He said, is this your book? Did you write this book? And he said, let's go to chapter whatever it was. I don't remember. I just remember the event. And he went to that chapter and he said, would you read page 4 of that chapter and paragraph 3? And he read that paragraph out loud in the courtroom, and it was exact opposite opinion of his findings. And at that moment, that courtroom went silent because he had destroyed the psychiatrist's credibility by showing him that what he was saying this time was his exact opposite of what he had said before. So what you want to do is obviously read articles that these people have done, read books they've written or chapters in books they've written, and also to find out if they've done speeches. Find out what kind of speeches, what are they talking about, what's their expertise, where are they really interested in, what's their unique character in terms of how they are using their skills as psychiatrists, psychologists, addiction experts, MSWs, defects experts, how do they get by in terms of what they do for that particular client that you're representing? For example, you have an MSW who does therapy. You have addiction specialists who work in the therapeutic environment to try to get people off drugs and alcohol and sex. You have defects, you have marriage and family counselors, you have battered women syndrome people who specialize in that, who specialize in analyzing whether or not that syndrome, and it's now battered person syndrome because it also affects men, that these people are experts on that particular subject. So if you have a PTSD case, or if you have an addiction case, or if you have some other bipolar, psychiatric, or psychotic disorder case, you got to find out if that expert the state is bringing in is actually an expert in the area in which you are seeking information about or want to cross-examine that particular witness. So in order for you to understand the issues you have to address, you also have to find out what is that person's specialty. And you need to read anything you can find on that individual. Now, it's not that hard to find, especially with Google and Facebook and all the other internet activity options you have. I particularly find a lot of stuff on Google about an expert and find a lot of stuff in their Vita, their professional Vita and resumes, and you can get that easily enough when the state notifies you of the person testifying. And here's the thing that's a problem for some of us. Competency and mental health issues are two different things. A lot of psychiatric people the state gets them to determine if someone is competent to stand trial. And competent to stand trial means that they can tell their lawyer and understand what the lawyer is saying in relationship to the defense they're presenting. I find this kind of odd, though, because when you think of competency and you think of your client sitting there who's had psychiatric or psychological problems that is the course of your defense, the competency to stand trial doesn't mean there's a competency in the entire case in relationship to the offender and the mental health issue that affected the offense. So when I hear people say this psychiatrist evaluated the person for competency, I want to ask that psychiatrist or psychologist, well, okay, but is the competency also relevant to when the offense occurred and what occurred during that time? And sure enough, it's not going to be, because usually they don't go into all of that sort of analysis. So when you find that out, you're able to ask questions that are more significant in relationship to even your competency question. Yeah, the person's competent to stand trial, but that's not your defense. Your defense is that there's a mental health problem that affected the criminal act in this case. I want to talk about the differences between psychiatrists and psychologists. Let's see here, I'm at the wrong way. All right. A psychiatrist is a medical doctor. And as a medical doctor, their type of interview technique is interviewing the client specifically in an interactive conversation. They're not inclined to be involved with testing that client through psychological tests. And you can get some real gems if you find out that they did not do any psychological testing or get a backup of psychological testing from a psychologist, which I'll address shortly. But the psychiatrist is a medical doctor, and as a medical doctor, their tendency is to use medication. And that tendency is based upon interviewing the client and getting an analysis that they think they can determine from their analysis what medication that person needs. So you have a plethora of questions that you can ask a psychiatrist related to what they did or did not do in interviewing your client, particularly if they just interviewed him. Is that all you did? Is that the only thing you did? Did you not give any testing or backup testing to make a determination of your diagnosis? And then what medications did you recommend? Did you look at anything else behind the scenes of that client besides just the interview? I don't know how many of you have run into that, but I was a therapist before I was a lawyer, and then I became a lawyer, and I still think it's being a therapist. But nonetheless, having done that, I've watched psychiatrists and what they do and how they do it, and they have a simple approach to the client. They're going to interview the client, and after 2.5 hours of interviewing, be able to tell you, allegedly, the diagnosis of your client's problem, if they diagnose them at all in your favor. So you want to know if this particular psychiatrist has a specialty. Are they a specialist in working with children? Are they a specialist in working with adults? Do they know battered person's syndrome? Not every psychiatrist can do everything. So if you have a battered person syndrome case that's affected by PTSD maybe, you want to be sure this psychiatrist the state is presenting or the federal government's presenting to offset your defense has in fact experience in that area, forensic experience. Are they a forensic psychiatrist? Some are, some aren't. So you want to know what they are, what they specialize in. You can go back to their education and ask them, what were you educated in? When you were educated at whatever medical school, what were your routines? What did you do in your little sections that you had to go through to get your degree? And what you have to ask them is, did you actually get any training in PTSD? And I guarantee you, most of them do not. Did you get any training in battered person syndrome? We have a case right now where this woman is in battered person syndrome and PTSD was connected to her husband, raped her, allegedly, this is all alleged, raped her on one night, and the second night he was coming to rape her. She pulls out a gun and shoots him. The difficulty, of course, was that she had walked up to him after she shot him 4 times and shot him 2 more times in some personal areas. No offense to the gentleman in the room. But having done that, her defense was battered women syndrome, battered person syndrome, and PTSD. And the state presented a psychiatrist who, in fact, was not trained in those areas, but alleged because they were a forensic psychiatrist that they could make that determination that, in fact, that was not the case in light of the information they had. And we'll get into something more about that information the government gave them to give that analysis, because the psychiatrists actually used the government information to help them decide that this person was not suffering from battered women syndrome and PTSD. Now, on PTSD, it used to be called shell shock. It's a really big deal right now in terms of how it affects our military, but it's not just a military issue. You can get PTSD from any kind of event that may occur in your life. And so as a result of that, you want to be sure the psychiatrist or psychologist you're working with is in fact someone who has experience in the area that you need them to have the experience in. What's missing from the psychiatrist is, besides seeing your client, did they do any other type of evaluation? And again, have they testified before the state? How many times have they testified for the state? What did the state give them to testify about? What did they tell them they were looking for? What kind of information was the state asking them to discover with the client so that they could offset the fact that the defense was going to present a defense that they're mentally ill and that affected the criminal conduct in the case? So you're going to be asking those kinds of questions. And then, did the psychiatrist evaluate your client at the time of the offense? I think we all know this, that the evaluations that we do and you do and the state does are always after the fact, right? They're always after the crime has occurred. How much time after is some of the questions we have to ask? How far after the offense did you evaluate the defendant? And then you need to ask, could the evaluation you did when you did it be different than if you had the chance to evaluate the client at the time of the offense? And most everybody, if they're honest, will tell you yes, because you have information at the time of the offense that your client was not well, mentally unstable, and had affected what they did in the offense. And this is the kind of thing you want to ask the psychiatrist. How much later do you interview him? How long was the interview? Again, that's a fact that is important, because sometimes the psychiatrist is only going to interview the client for an hour and a half, 2 hours. But if you know that, that'll help you. And if you get the report, it's just 2 pages. A 2-page report is not a good psychiatric evaluation report. So you want to find out what's behind the scenes and what they didn't do or did do that will help you. And some of that is a development of the term competency versus mental health. Ask the psychiatrist, did you evaluate for competency, and what is competency to you? Could the person have been incompetent at the time of the offense, even though they're competent now to stand trial? Absolutely. You're going to get an answer that should be yes. But here's another thing you need to do also, is consult with your own experts. And I know that money is tight for public defenders, and I know there's a lot of you here, and I know money is an issue in getting experts. My contention is you don't always have to bring the expert in to contradict the state's expert. You can also just consult with an expert by talking to them on the phone, ask them what questions you should ask the psychiatrist, or give them the report the psychiatrist or psychologist gave the state, because you're entitled to that, and let your own expert at least talk to you about what's in the contents of that, to see if that will help you in any way in cross-examining the state's expert. If you have the money, obviously my recommendation is to do a full evaluation of the client on your own And when you do your own evaluation, it doesn't mean you have to reveal that to the government. It only means you have to reveal it if you decide to use it. So if you get it and it doesn't look good and it's not going to help you, don't use it. Don't give it to the government. Don't make it part of your case. But you can still cross-examine the state if you use that as a defense, that the mental health issues that your client was experiencing in fact affected the crime. And look, this is also a trial issue and a post-conviction issue. You can use your defenses at trial and cross-examine the state's witnesses to prove that they didn't do the right evaluation or it's not enough, or you can discredit their psychiatrist because that person doesn't have forensic experience, doesn't have the experience in battered women's syndrome, doesn't have the experience in PTSD, doesn't have the experience in whatever it is you're trying to say was the reason your client was affected in doing the criminal conduct that they did. So the theme here then is that after you get through with the psychiatrist and melting them down a little bit, then you're going to find out that the psychologist is the backup for the psychiatrist. A good psychiatrist, and when I was a therapist, this is what I used to do. I used to do the testing for the psychiatrist. I did all these different tests that we have, and I'll get to what they are, for the evaluation so that I could back up what the psychiatrist was saying was actually going on at the time. And what happens is that the psychiatrist should be asking for this information in addition to their individual interview in order to prove that what they're saying about the client or the defendant is accurate. So if they didn't do this, this is a really valuable cross-examination questions that you can use when you're talking to the state or the federal psychiatrist. If they did not use backup testing from a psychologist, there's a flaw in their evaluation. And if you ask the psychiatrist, do you use backup psychologists to do testing for you to help you with your diagnosis, and they say no, then you've got something there, because then you bring in a psychologist and say, why do you use these backup tests? It's to prove or disprove a particular mental health issue exists. And so the psychologist is an important part of the structure of your expert in terms of whether or not they're doing the right thing and doing all the things necessary. So that not only do you want to get the psychologist involved in your case, but if it's not involved in their case, it's something you can do in cross-examination. And it's an important part of that cross. Who did the testing is important. You want to know who that person is as well. Who did the testing is a person that you need to know as an expert in that area that you're trying to use or cross-examine the state to keep them from getting the negative into the jury's mind about your client's issue, which is whether or not I'm going to use PTSD because that's something that I have worked a great deal with, but if the PTSD in fact affected the outcome of the offense and whether or not they were qualified to do PTSD evaluations, understand them, and they did them properly with the backup testing that I've just described to you. There's an article in the Federal Lawyer magazine from 2010 on the history of PTSD. It's worth reading. I wrote it. That's not why I want you to read it, but I didn't even want to say that, but nonetheless, it's really, when I did the research on it and I really went back in time, it was so interesting to see that the PTSD actually existed long before they called it PTSD. It was called shell shock. And so for what it's worth, if you get into that type of situation, you want to ask the state or federal psychiatrist who's trying to say the PTSD doesn't exist or didn't exist in your client, you want to know the history and the development of it, because it's a valid defense when you're looking at your client for mitigation or for defense at trial. So the testing that you want to know about, let's see here. I don't know how many people know what kind of tests are given. Anybody here recognize the kind of test that's up there? How many people have had the MMPI used in a case to give you an evaluation? A couple of you have. And that's tended to be the norm. That tended to be the norm for evaluating clients quickly. It was a 500-question test, and then it turned into a 300-question test. And the design around the MMPI is that it is a quick way, supposedly, of analyzing any neurotic or psychotic condition that you might have. But if any one of you took that test, you would all be neurotic. Some of you might be psychotic, I'm not sure. I know when I took the test, I was really surprised at what it said about me. So one of the factors about the MMPI, if you see that in the testing grouping that the psychologist does, is to know that this is the one test that has a lie factor scale in it. So it shows that if your client is attempting to manipulate the test, it will come out as a lie factor, and they'll show that your client is not doing well in that testing proceeding. And so as a result, it does have a way of showing that this test is either truthful or not truthful. But the other tests, you can't do the MMPI, and I bring this to your attention because so many people just rely on the MMPI. If you see it as the only test that was given, stop and say, wait a minute, that's not enough, is it? No, it's not enough. The rest of these tests are important. The thematic apperception test, the Gestalt, and the visual interpretation testing, intelligence, IQ, and all that. If you do these groupings of tests and you're a psychologist or the state doesn't do it, you have great cross-examination questions because you're not getting from the MMPI an intelligence or an IQ result. You're not getting from the MMPI a perception of how they perceive life. The thematic apperception test is a test with pictures. I don't know if any of you have ever seen it. It's, for example, one of the pictures is a mother and a child. What does that say to the client who's being evaluated? Well, when you look at it, some of them say, that's my grandma, and I'm running to my grandma because I feel safe with her. Other people say, that's my mom, and she's just loving me. Well, which is the right answer? Which is the wrong answer? And it's not a right or wrong test. That's the difference. What it tells you is a little bit about the perceptions of your client and how they see the world. And it can help you analyze the cross-examination questions to the prosecution's case on determining whether or not those tests were given. You've got to get an intelligence test. Many of you have dealt with people who are intelligence level. It's not an insult. The intelligence level is lower than it could be for them to understand or cognitively recognize some of the consequences of their actions. This is particularly true with juveniles. And I'm finding, I've got plenty of juveniles that got life in prison at the age of 14. And of course now, where they're saying you can't do that anymore, which is we're grateful for. But there's no way they had the cognitive development to understand the level of consequences from their actions. So when you talk to your experts, you've got to know what these tests are, a little bit about them, and an ability to actually respond to them and ask questions and cross-examination about them. If the state has done that or the feds have done that with their expert, it's a really good way to know. And they should report it in the reports. If you get a good report, it tells you what tests were given. It tells you what the answers to this test were or the interpretations of those tests are. I've seen too many state and federal prosecution expert witnesses not have that in the reports. And it gives just a wonderful, wonderful amount of opportunity to ask questions on cross that are really, really fun. All right, so we've got the foundation, we've laid the foundation, you know who these people are, you know the players, you know your expert, you know your defense, and you're using your expert now, and then they're going to use their expert to destroy yours and say, no, this is the right perception of the case. So here we go. We got cross-examination. How many times have you testified for the government? This is a good question. The prosecution asked our experts the same thing. How many times have you testified for the defense? How much money did you get? I got $4,000 to do this. That's a lot of money. How much did the government pay you to do this testing? It doesn't matter if it's $200 or $500 or $10,000. Just ask the question because it makes it important enough for them to know that they got paid to do this. But now you get to move into the next set of questions. Not only what it is the government paid you, but what did they request you to do? And how did they request it? Did they get you to look at discovery? Did you look at discovery? Did you talk to the agents? Did you talk to the police officers? Did you talk to the prosecutor? What did they ask you to look for? Usually there's going to be an answer to that helps you define that they were actually being biasly led into finding a particular outcome that would help the government. So you can get there by asking some of these questions. And of course, did you visit the client and how long? All right, let's continue with the cross. And in your materials, not the tequila part, but the general materials, you'll find all these questions I've given you, probably over 100 questions I've suggested might be valuable for your needs. And when you look at the questions, please understand that I recognize some of them won't work. Some of them will work, and you might just throw them all out and say, none of this works with my situation. But it's only a suggestion to help you get jump-started into the process of figuring out what works in your cross-examination on a mental health expert. So here we have some additional questions. What testing did you do while visiting with my client? It's important to know that because if the visit occurred with no testing and the testing occurred sometime later, that's another gap in between the time in which the psychiatrist may have interviewed your client and the testing may have been conducted. What materials other than interview or testing did you review? And again, this is a good part of it. Did you talk to the agents and did you talk to a family member? Did you look at medical records, if there are any, and if your client had been in treatment before? You want to know that. You want to find out. Did you look at my client's medical records or my client's history of mental health problems? I mean, when you have a mental health patient or client, that you got to know there's a history, right? It may not be a hospital history or a place where they treated them. It may just be that the parents and the family know that that person's been depressed. They've been they've been screaming and hollering. They've been agitated, anxiety levels are high. You ask family members how someone's acting when you think you have a mental health case, and you're going to get more information than you're going to get from the psychiatrist. They're going to tell you the truth about what's been going on. So you want to ask the psychiatrist for the state of the feds, what other things did you do to corroborate your test results or your interview results, depending on whether they only did an interview. So that's a critical part of it as well. And now this says voir dire and cross, and it's not meant to be voir dire and cross. You can use one or the other. The real thing in voir dire, when you're determining whether somebody's an expert, whether it's a trial or in post-conviction capacity, as in a habeas or in a motion for new trial. In Georgia, motions for new trial, you have an opportunity to bring in and say ineffective assistance of counsel for failing to bring in an expert. And you can bring that in at the motion for new trial setting because they require us to bring in ineffective claims at the first opportunity, which usually is right after the trial. So many times, a lot of lawyers don't use their own experts, and that's become an ineffective assistance claim. But it's not going to get you ineffective if it's not founded on some substance. So one of the things you want to do is when you get an expert from the state, you want to voir dire them carefully. That's why you have to know their background and know what they've written or what they've spoken about to see if, in fact, they have a forensic background and if they are experienced in the things that we talked about earlier. So the voir dire can occur in front of a jury or it can occur in front of a judge in any kind of proceeding. And in the proceedings, just ask the questions about them and don't be afraid of those questions because those are going to be helpful to you in figuring out if they are truly the expert. You can argue and object to the fact that they're not an expert on PTSD. How many cases, here's a psychiatrist, the psychiatrist in the case I'm working on gets on the witness stand, and he's a forensic psychiatrist, so he's got forensic experience. But I asked him, have you experience with veterans? No. Have you experienced with PTSD? Yes. How many times? Twice. Have you testified on PTSD before? Yes. How many times? Once. That's not enough. That's just not enough. Have you testified about bipolar disorder? Oh, yes, I've testified about that a lot. I said, well, how many times? 10 times. Okay, that's decent. That's not bad. But the PTSD part was the critical part in the case that I've started out with. And that's the part that we wanted our experts. Our expert got on the witness stand, and we had a PTSD expert. And that expert said, I said, how many times have you testified on PTSD conditions? 200. And I said, well, how come 200? That's what I specialize in. And why do you specialize in that? Because I work with the veterans. I do volunteer work with veterans, and I do volunteer work as a therapist with PTSD people. And does PTSD occur in other people besides veterans? Yes. Could PTSD be triggered by certain elements? Yes. Can that element be at the time of the offense and not later on? Yes. Is the time of the offense a trigger? Yes. I mean, by the time we were done, our expert was clearly much more qualified to talk about the case that I referred to. So you need to voir dire your expert and the state's expert to see if you can at least discredit them to some degree. That doesn't mean that the court's not going to listen to what they have to say, and doesn't mean that the court's not going to say, okay, I'm going to listen to them anyway. They have enough experience. I'm going to hear what they have to say. That's why you need your own expert. It may not be easy to get that expert, but that is something you have to consider. On page 13 of the materials, there's some really good additional questions. Something like, doctor, were you retained by the government? At what cost? You do know the proceeding is an adversarial one. These are good cross-examination questions. You do know that this proceeding is an adversarial one? Yes. Were you asked to give an opinion from your expertise before trial? Yes. You were not part of the government's case for preparing charges, were you? No. So when you entered the picture, the government had already charged the client? Yes. The government has on one side of the case and the defense is on the other, correct? So you're working for the government, correct? So see how that goes? It drives them into a biased opinion just like the state would do with your expert. So you have the obligation to do the exact same thing. Drive them into the prejudice, bias, and questionable testimony as to what they might testify to. Now, another good question, and I think it's going to come up in a minute anyway, but I'll talk about it for now, is another good question is, when you evaluated my client and came up with your opinion, is it possible that someone else could do the same evaluation or even more testing evaluation, come up with a different opinion? If that person's honest, they'll tell you yes. And of course, your expert's going to come up with that other opinion. The same thing with, is your expert, that expert for the state, how many times have they testified for the state? And then ask them, have you ever testified for the defense? And you know how you can find out this? Just pick up the phone and call the state's expert. You're allowed to do that. You are allowed to call up the state's expert. A brief story is that we had a case where the expert was an ME, wasn't a psychologist, psychiatrist, was an ME, and the case was about struggle over a gun and whether or not it was murder or an accident. And the lawyer in the case did not get an expert of their own and never spoke to the state's expert. The state's expert was never asked the question, could the striation injuries on the stomach be classified as a struggle? No one ever asked it. Of course, the state didn't ask that because that was the defense's position. And so when the ME was testifying, he just testified about the striation and the general medical condition of the body. No cross-examination was given. None. We called up the expert on a motion for retrial hearing, and the expert said to us, "This is the state's expert." We called him up and said, "Hey, could this have been evidence of a struggle?" "Well, yes." I said, "Well, why didn't you say that in the trial?" "Nobody asked me." Nobody asked me. And so the whole story of the case was blown because that cross-examination on that one question wasn't asked. So calling up the state's expert is allowed. And asking them questions to help you define what you want to do with that state expert is extremely valuable. You don't have to. It's just something I recommend if you can reach them and if they'll talk to you. Because, you know the state they're going to say, you don't have to talk to the defense. You don't have to say anything to them. They do that with all their witnesses. All right, so the pages in the materials 12, 13, 14 are a bunch of questions. There's other questions, the client's mental state during the commission of the crime. Is it fair to say that that could have been different now than it is then, just like I said, and so on and so on. Two really hot button questions that I think are the most important are, is it possible if someone else evaluated, tested my client, a different result could occur? And you'll know that if you have your own expert and you have the expert do the testing. You'll know if there's a different outcome. It may be the same, I'm not saying it's going to happen, but most of the time there is a different outcome. And the second question, is it possible that if testing or evaluation were done at the time of the crime, that a different result would have occurred? And I think those two questions are extremely important. I have a little bit of time and I want to talk about the case that I started with. This is Mr. Rawl. His real name is Mr. Ball. That's part of the tequila typo. So in the end, this is who he was. This is who he was. And at the bottom part of that, this is what he started doing. And what he did, and the trial lawyer, he sent 150 letters to the trial lawyer on a 3-month period of time, 6-month period of time. And in those letters, they were scattered all over the pages. There was writing on here, on the margins, all over. It was, I want to kill everybody, get me out of jail. And they were repetitive, but those questions, those letters were 5 to 10 pages long, front, back, margins everywhere. So you knew there was something wrong with this guy. The trial lawyer did nothing, got a competency evaluation only, did not go and get a mental health evaluation. When we got the mental health evaluation, as you saw on the slide before, he had suffered from these particular conditions: PTSD, bipolar, OCD, and so forth. He committed an arson in the state, got sent to prison. We did not represent him then. He gets sent to prison, and we start getting 200 letters over a period of 6 months. Same kind of letters. Rambling, crazy conversation, repetitive. Every letter was the same. It was, get me out of jail, plead mental health, I'll plead NOLO, get me free, I paid you, and I paid you money, you should be able to get me probation, and I'll do banishment. I mean, it was chaotic information. It's hard. I almost brought all the letters so you could see them. It was just massive, but it was too much to carry. So in the end, when we started getting this, I knew immediately that we needed a psych evaluation. So we get the evaluation. And this is the case I did in front of Judge Duffy. But how he got to federal court was because while he was in prison, they stopped giving him his medication. And stopped giving his medication, the end result was that he started writing letters to the Georgia Bar and the AJC with inside of it, let me see if the letter will come up here. Let's see. That's the kind of this is the kind of letters he was writing. But this, you got to picture this on every page, massive amounts, even more than that. And it was hard to just get a picture of it by just using this one letter. But this is kind of the thought on that. But here's what he did in prison. He says he wants to kill everybody, and he writes this in third person. He writes it as if it's somebody else, not him. And that he writes the letter, and he says, we'll kill you all, and our family, your families, and cutting all your throats. I know where all your people lived. I'm going to blow up your church. Have some anthrax. It got to be funny to us at the office. Have some anthrax. It's like, have a drink. He sends this letter to the Georgia Bar and to the AJC, the Atlanta Journal-Constitution. And hazmat had to come out because inside of it was soap flakes and salt. And so they thought, you know, if I got the letter, you get freaked out, right? So they had to call hazmat. Hazmat came in both of these places. He did a third letter, and hazmat came there. And every one of the letters says, have some anthrax, inside and outside the letter, on the envelope. Have some anthrax. The guy's crazy. And he wrote this, like I said, in third person. And when he got in trouble on the arson cases, he wrote it as third person. This poor 70-year-old woman down in Tallahassee picked up her name. I don't even know how he did it. And he was writing letters as if she was writing them, that she did the arsons that he got convicted of. So he had this whole pattern. And the federal prosecutor brought in an expert who said he could not define what kind of mental health problem he had. I was just stupefied. I said, really? I said, is that not your job? Yes. But how come you couldn't, what was it that you could not define? Well, the manner in which he writes looks like it's natural and he understands what's happening and why he's doing it. And then at the same time, it is chaotic and inconsistent and problematic. But he could not get to a definition. We got our own expert, obviously. And he said the PTSD, bipolar disorder, he has in and out reality experiences, which tends to indicate he's on a borderline psychotic condition. So in front of Judge Duffy, we brought all this to his attention. We discredited in a cross-examination the state, and Judge Duffy gave him 24 months in prison out of a possible 10 to 20 years. The best letter we got from him, and the only letter we got from him that was nice, was this one. He said, you and Miss Brandenburg, which is my law partner, because women know how to argue until they get what they want. This is the nicest letter he sent us. The rest of them were, you bitches didn't get me out of jail for the money that I gave you. And you can go online and Google and you can see he's saying, I spent $20,000 with you and you didn't get me probation. So he hates us now. And the letters keep coming about how bad we were and how horrible we were. He got out of jail. And guess what happened? He did it again. And so he's back in jail. He's a real messed up guy. I feel sorry for him. It's difficult if he doesn't take his medication. He's not gonna do well. And so we know that he is a mental health case, but we were able to discredit the state quite significantly in that case because when he said he couldn't come up with a diagnosis, we knew then that there was a problem. And that's why our expert became much more valuable. Finally, I hope none of you do this. And it's not just because I'm a woman. I like to have the last word. I'm sorry. That's just the way I am. And you can ask anybody that knows me. I cannot stop if I don't have the last word. And so I don't ever not cross. And I know some of you say it's great to just stand there and not cross. Sometimes you get what you want. And if you do, hey, that's a good thing. If you get something that's going to help you, you want to end on that, that's perfectly fine. But I'm always the one that wants to reinforce whatever was said to help me or cross-examine at least one question. When we got that ME in the chair, we asked that one question. Could that striation be considered a struggle. Yes, we walked away. That was it. That's all we needed. This is what the lawyer did at the trial. And this is what the judge said. Mr. T, do you want to cross with the machine? I don't have any cross for the doctor, Your Honor. You do not have any cross? No, sir. Don't do that. Don't be that person. Cross-examine these people, because I'll tell you what, the questions you ask will get you what you need to show that that person either didn't do what they were supposed to do, did do what they were supposed to do, and can help you. And separate between competency and mental health problems. And that mental health problems do affect criminal conduct on many, many occasions. So evaluations are critical, even if it's just for your education, just for you to be informed. So what I would like to do is, if anybody has any questions, because I have a few minutes, I think. I got a couple of minutes? Okay, I'd love to answer some questions, because I'd like to do some interactive discussion about cases you've had or things that have happened to you. Yes? What's the machine? Oh, it's the overhead. Using the computer and the overhead to be able to show visuals. And visuals, of course, are important, and you've seen that in a lot of the discussions today, that visuals really have an impact on cross-examination if you can get them to work for that particular mental health person. Yes, sir. No, good question. He's saying, if you bring your own expert in, do you still want to cross the state expert? Absolutely. You've got to get them less credible than your expert. So the cross-examination of that individual is very critical, and that's why I told you about where the federal expert couldn't come up with. I mean, he did a real nice 10-page report. The report was very extensive. I can't deny that. But when we got to the bottom line and asked him, well, what diagnosis did you come up with? He said, I just can't come up with one because of all of the different elements of his behavior that were inconsistent with some of the facts of the case. So that's what happened there. Yeah, you got to cross them. You got to ask them, did they get paid? The questions are in your materials about not just getting paid, but did they also get told what to look for? Did they talk to the agents and the officers? Did they look at the discovery? Because if they know about the offense, then you've got some really good cross-examination questions to ask, especially about whether or not the condition of that defendant at the time of the crime would be different than when you analyzed them or tested them. Yes? Right. She's saying, her question was, and it's really a good question too, because Butner has these problems with the inmates that are there for mental health treatment. If your client's not participating or is resisting participating in taking medication and not responsible, doesn't want to, and doesn't want to participate in the conversation in the testing process, that's a problem. But that's also a diagnosis. That's also a diagnosis that a psychiatrist could be able to come up with in relationship to why they're behaving that way and what is the reason for that conduct and how it is affecting their incarceration. In Butner, they do a lot of competency and mental health evaluations for the federal government, and resistance is futile as far as I'm concerned. If anybody ever saw Star Trek The Borg, resistance is futile when it comes to the feds. Any others? Yes? Yeah. Another good question. In the report, you can get good things and bad things, right? Some of the things that are in there are going to be not so good, and some of the things are going to be helpful. You have to make a decision, it's a tough decision, on whether or not the report will help you more than not. And again, you may have to do cross-examination or direct examination on the highlights. The government's going to hit the bad stuff no matter what. And you need to hit the bad stuff for the state, because their report's going to have the same thing, you hope. Because they're going to say only one thing. So when you cross the state, you just cross them on what they're bringing up that's so bad, and then you bring up that even though you have some bad stuff in your report, what's the good stuff that helps you? And then the state's going to cross on the bad stuff in your report as well. But then you go back and you get at least one more question on your own, redirect on at least one more question on your own expert that brings them back home to the good stuff that helps you. It's not easy. You have to make a tough strategic call if what's going to make it better for you. If you have no defense but this, I don't know how you don't use it. I don't know how you can't use it. It's just you're going to have to make that tough call. Whether it's too bad, don't use it. If it's not really going to help your defense or where you want to go in mitigation, don't use it. If it does, and if it's half and half, you have to figure out how to make that half work for you, even though the state's going to focus on the bad half. But use that last direct question that you have the right to use to bring back home the good stuff, the stuff that makes a difference. Thank you very much. I really enjoyed it. Thank you.